Okay, the next case on the docket is Gonzalez versus State. Whenever you're ready, counsel.
Good morning. I'm Eric Pinkard from the law firm of Creed and Pinkard on behalf of Mr. Gonzalez. The first argument I'd like to present today is claim number one of our appellate brief, is that the lower court erred in failing to grant an evidentiary hearing on the claim that the trial counsel was ineffective for failing to properly argue for a change in venue in this case. I don't think I have to remind the court that you have repeatedly stated on many different occasions that trial courts ought to grant evidentiary hearings and post-conviction motions on cases where they require a factual determination.
Well, this is a little bit of a hybrid. Am I correct that the trial lawyer did make the motion for the change of venue?
Yes, he
And
absolutely
so what
did.
your position is that he did not or she did not argue that motion or include in the motion or do it appropriately. That's the essence of your argument?
Yes, essence is a Strickland argument that the counsel was ineffective for the manner in which he presented the argument on the change of venue. And the first reason he was ineffective is that he didn't put before the trial court all the pretrial publicity that was available for him to put to the judge to try to explain why he needed a change.
Did the trial judge on this case, is my understanding, that the trial judge during voir dire did address to see if they could seat a jury without an adverse publicity problem. And that what happened?
That is what happened.
And isn't that what trial judges do and are taught to do before just automatically granting?
Right. Well, in the Manning case, it was cited by the trial court. The trial court can proceed in two different ways. He can review the evidence as put before him by the trial counsel, or he can attempt, after having that information, to try to seat the jury.
Right.
And see
and
but in this case, what happened was that the jury was never questioned about what they knew about the case. All that happened is that the state attorney stood up and said, does anybody know anything about this case? Every single person in the room during the voir dire raised their hands, and then they said, can you set that aside and still give Mr. Gonzalez a fair trial? That's all the questioning that was had before the jury. So we don't know what information these particular jurors knew about the case. In other words, there was no individual voir dire, but despite the tremendous pretrial
So it was the voir dire,
publicity,
not the motion itself. It was the extent of the voir dire of the panel, prospective panel.
well, I submit it's a two-step process. What you're supposed to do as trial counsel, first you submit all the information to the judge that you have on the basis of the pretrial publicity. And then the judge takes that information. You don't ask the judge to take judicial notice that there was pretrial publicity because you don't know what the judge watched or what the judge didn't watch. Once you've done that...
Maybe I'm wrong. You should correct me if I am. But I thought that this record reflected that the judge indicated on the record that the judge was very familiar with all the pretrial publicity.
What does that mean? How do we know what the judge was able to absorb in the pretrial publicity? What television show did he watch? What did he read?
So you're asking judges in the future that they have to sit there on the record and list everything they read about the case and so on? That's the record that you're requiring for this type of cases?
Well, I don't know how you can make an appellate review of whether or not there was pretrial publicity sufficient that no juror could be assembled in that jurisdiction, or in this case, Pensacola,
let me ask you
unless
this.
you got a record of it. The judge just says, oh, I reviewed everything. What does that mean? We don't know what it means.
Perhaps I'm wrong. Wasn't there a questionnaire for the jury in this case? Was a questionnaire?
I believe there was a questionnaire, yeah. I can't recall it.
And did the questionnaire address the issue of publicity? Did the jury fill out a questionnaire and did it address the question of publicity in the case?
I don't think it's in dispute by anybody that the jurors said they'd heard about this case. everybody in Pensacola had heard about this case. All these jurors during the
So what-
questioning
what did-
and
what-
in the questionnaire said, I've heard about this case.
So what is your expectation as to what jurors should be told at that moment when they said, I've heard about the case? Should the judge or the prosecutor or the defense counsel, somebody stand up and tell them every detail of the facts of the case to see if that rings a further bell? Or what is it that you want them to do?
I want them to do an individual voir dire of the juror, find out what they know about the case, just like happened in the Manning case, which is cited in the judge's order denying it. And Mr. Manning, they said there was too much adverse publicity. They went through the process of asking the jurors what they knew. The jurors told them what they knew, and this court found that due to the nature of the pretrial publicity, that there couldn't be a juror put together in that jurisdiction. And if you look at it in the judge's order, there's also the Coleman case, which is from the 11th Circuit, which stands for the proposition that normally in jury selection process it's a very high standard to get a change of venue. And in that case, the judge did exactly what happened in this case. They tried to sit a jury, and they asked these conclusory questions. And what that court held was questions along the line of, have you heard anything about this case, and can you put it aside, are not sufficient to find out what the jury knows about the case. And conclusory protestations of impartiality is not enough, and that's the Kemp case. So in this case, we're trying to decide an issue as to whether or not there was pretrial publicity that so pervaded the community that made selecting a jury in an impartial jury drawn from that community impossible. We don't have a record of what they knew. And because the trial attorney did not put forth a record of what they knew. But what we do know is in our 3851 motion, we were specific about what we made a facially sufficient claim about what had been alleged or what type of pretrial publicity had taken place. And the type of pretrial publicity that would have taken place were that the sheriff of that particular jurisdiction had gone out of his way to go on television to talk specifically about Leonard Patrick Gonzalez. And he called the killings to be execution style. He said it was a contract killing. He said there was drug connection somewhere. He said that Mr. Gonzalez always wanted to be a mafia guy. He said Sheriff Morgan specifically referred to Mr. Gonzalez as an inveterate liar and a psychopath. He said he was a lying con man. He said that the Billings murders were a hit, and they were done because of resentful business rivals. He said that the people were afraid to testify in the case because they were afraid of being whacked by Mr. Gonzalez. He said that Mr. Gonzalez was involved in the Mexican mafia. When he was put forth the information to him that Mr. Gonzalez had requested bond, he publicly said, and people in hell want ice water. He called Mr. Gonzalez diabolical, evil, and manipulative. And he talked about the whacks and hits he had given on other people. And this is pervasive, continuous, over a long period of time, media coverage of the Gonzalez case. And they also released all the statements many statements of individuals that never testified on the case at all. Leonard Patrick Gonzalez Sr., Hugh Wiggins, Cab Tice, and Pamela Long. There was also numerous and repeated newspaper stories about the victims in this case, and that there were special needs adopted children were involved, and front page stories about the tragic impact that these killings had on the family, and especially the needs of the children. I'd like to also cite from, in the Manning case, they discuss Manning v. State, which is the one cited by the court for the proposition that and denial of the motion. They cite the Singer case within the Manning case. This court cites a previous decision by this court, and I think it says it better than I can say it. Talking about pretrial publicity in a case. Law enforcement officers likewise must be required to abstain from making pretrial statements regarding the details of the crime under investigation. Such statements and evidence either may or may not be omitted. Yet, if those who sit on the jury have read the press reports, it is most difficult, if not impossible, for the human mind to not be fill in from its extrajudicial knowledge that which was not offered at the trial. That is exactly what happened in this case. By design of Sheriff Morgan, he's the one, he wasn't being asked questions, he went out and held press conferences specifically to call Mr. Gonzalez a liar in the jurisdiction where this case took place. And we have no idea whether the jury that was selected to hear this case heard that information, because they weren't asked at voir dire. And if they did, there's absolutely no way you could possibly have a fair and impartial juror in that jurisdiction.
I want to ask you a couple of questions about your second point on appeal. Your contention that the grand jury panel may have been tainted somewhat by the sheriff making an appearance and saying hello to jurors when they first come in, something like that. Can you tell us what that's about? What was it that the sheriff did?
Okay, well, that started when three different federal United States District Court judges in the Northern District of Florida wrote a letter to Sheriff Morgan, because the federal juries the juries for the federal court and the state court, they all begin the journey by going to this one parking lot where they're brought to the various locations. Whether you're going to be on the grand jury, whether you're going to be on the state jury, wherever you're going to be, you're brought to this parking lot. And what was happening was people were showing up at the jurors, potential jurors for these federal cases in federal court, with Sheriff Morgan's business card, because he was going to greet the jurors, and in his words, as he admitted later, to put a positive light on law enforcement. And so the federal judge wrote Sheriff Morgan a letter and said, your interaction with these prospective juries raised legitimate concerns about the court's ability to seek fair and impartial jurors,
and
especially...
What date is this letter?
March 3rd, 2011. Especially when considering that the majority of those selected will serve on criminal juries. The potential for bias created by senior elected public law enforcement officers greeting prospective jurors and handing out business cards to them just prior to jury selection is undeniable. Now, that's three federal district court judges who went out of their way, all three of them, one of them the chief judge of the middle district for district court judges, to ask Sheriff Morgan to stop doing this. Sheriff Morgan did not stop doing this. And you have to remember, this is not just any person that's greeting jurors and to serve on the grand jury in the Gonzalez case. This is the very person that's appeared numerous times, going out of his way to slander Mr. Gonzalez, to say he's an inveterate liar, he's a hitman, he's a con man, and this is the guy going out giving his business cards to the potential grand jurors in this case. That is totally unacceptable. That is a corruption of the system.
Did you mention earlier, correct me if I'm wrong, that the federal courthouse and the state courthouse are adjacent to each other and they share the same parking lot? I don't know my way around it.
It's a little unusual, I understand. I don't know if it happens in every jurisdiction, but the information is that they go, because the public defender got involved and tried to get Sheriff Morgan to stop doing this. I don't think it's in dispute, and we allege in our 3851 that they all go to the same spot, and then they're taken either to the federal court. There's a trolley they gather, the trolley comes, they take them to the federal courthouse, or they take them to the state, and then they can either be a member or whatever. They could be a civil jury, criminal jury, whatever. So that's just like a starting point. And that's why Morgan was going there, because he knew that was the starting point for the jurors, because he wanted to make political points for the jurors.
Well,
he wanted to put law enforcement in good light.
If a citizen gets a summons to appear for a federal trial, and another citizen gets a summons to appear for a state trial, both will go to the same parking lot, and from there, they will be taken by trolley to either the federal courthouse or the state courthouse. Is that the way
That
that
is,
works?
that is what we found out to be the system, and that's what we allege in our 3851 motion, that the state jurors would be in that same parking lot that Sheriff Morgan admitted that he was going to, specifically because that was the day that they showed up for jury selection, either Monday or Tuesday. That's his letter and his affidavit that he gave in response, because a lot of lawyers got involved, and the chief public defender got involved. He finally agreed that he wouldn't go down there when the Billings cases were coming up for the regular jury, because he said, well, I can understand why that would potentially be prejudicial, because I'm the face of that case. Yeah, well, he's right about that. He is the face of the case.
I'd like to go back and ask you a question about the other issue. Are you familiar with our decision in Caratelli?
I don't believe I am.
Okay, in Caratelli, we held that a defendant could establish the prejudice element of an ineffective assistance claim with respect to the selection of jurors only by proving that a biased juror served on the jury.
Right, well, I think we have a different body of
Well,
law.
I understand, you're talking, this is change of venue, but kind of at the heart of this is this failure of counsel to do what it took as part of the jury selection. Because it's certainly conceivable that we could have had, the questions you say should have been asked, if they'd been asked, then the responses might have been such that we would have felt that it would have been perfectly proper to seat the jury and proceed, correct?
Yeah, but I
Okay,
understand.
so at the heart of your whole claim really is the ineffectiveness of counsel in jury selection. And so I'm having a hard, and again, perhaps I'm wrong, this is not something I think either side has talked about in this case, am I correct? Caratelli?
I don't think it's been cited by either party,
Okay.
but, yeah.
Well, I'm just, Caratelli's not a decision that was kind of made in a corner somewhere. I mean, this is a significant part of our jurisprudence in Florida on ineffective assistance claims in the post-conviction with respect to a juror selection. So I'm just having a hard time understanding why this might not have some possible application.
Well, I would argue that there's a presumption of prejudice in a situation where you're able to prove that the pretrial publicity was such in that area, and that comes from the U.S. Supreme Court. That's the whole body of law that we're trying to go on. So I haven't read the case, so I'm just trying to distinguish it, but I think that prejudice is presumed. Nobody, and even if they say, yeah, I could set it aside, if you have that much information, then you just can't have a jury in that county, and especially when you got the sheriff who's trying to make Mr. Gonzalez out to be public enemy number one for months and months and months and months and months, daily, almost daily, leading up to this trial. It's a massive amount of pretrial publicity in this case. So
You're down to like a few minutes for your...
Yeah, I know.
If you want to keep that.
I'll sit down.
Good morning. May it please the court, my name is Lisa Hopkins, and I'm appearing on behalf of the state in this matter. Summary denial was wholly appropriate in this case because even accepting the facts as true in appellant's motion to vacate the conviction and sentence, he would not be entitled to relief under the law. I would like to start with issue one. Chief Justice Labarga, you had asked if there was a questionnaire. There was a questionnaire. It was filed by defense counsel pre-trial. On the date that they addressed the motion for change of venue, they actually also addressed the questionnaire. The questionnaire, the first three questions had to do with the pretrial publicity. The first question being, have you heard about the murder of Byrd and Melanie Billings that happened on July 9, 2009? The second question being, what have you heard? Please explain. They were given 3 lines to provide what type of publicity they had heard about this case.
Let me ask you this just as a point of information. The murder happened in July of 2009?
Yes, ma'am.
When was the jury selection?
The jury selection was October 25th of 2010, so a little over a year later. And then the third question on the questionnaire was, have you formed an opinion on this case? Please explain. This questionnaire acted as the individual voir dire for the jurors. 84 of the prospective jurors that were questioned on October 25th, 2010 did answer those questions. The record references the questionnaires, specifically on page 207, Eugenia Hernandez, who was ultimately selected for this jury, did state that she, when asked, your questionnaire indicates that you had heard about this case, would you be able to put that aside? She indicated, yes, I can put that aside and base my decision on the evidence presented in court.
Were there any jurors who were actually excused because of pretrial publicity?
Yes, ma'am. Carla Godwin, Florida Broughton, and Richard Beddix were all dismissed for cause because they all indicated that they had followed the case and would not be able to put that aside and base their decision on the evidence presented in court. Justice Kennedy, you did bring up Caratelli. I am familiar with that case. I believe there is no bias on the face of the record from the jurors. And I believe that could be applied in this case as well when you're looking at an ineffective assistance of counsel for not properly arguing the motion for change of venue.
Do we have any cases where, I know that we've had change of venue ineffective assistance of counsel claims, I think but have we had any cases where we found ineffective assistance of counsel for not moving for change of venue?
I'm not aware of that, Your Honor, but...
Because I'm trying to, because Caratelli is, of course, good law, but I guess if it was established that the publicity was so pervasive that it was impossible to get a fair jury, you could say, well, they should have changed venue. But since here, as you said, you've got enough of a protection that what was done shows that it wasn't so pervasive, I think we're back to a mixture of a Caratelli standard, and that's sort of a friendly question. But there could be cases where it's so clear that this was the most notorious murder ever, and everybody knew about it, and it took 5 days to get a jury, but that's not this case.
No, Your Honor. Under the Rawlings case, it's a two-pronged test.
Yeah, maybe it's Rawlings that I was thinking about.
I believe it is Rawlings. That is a two-pronged test. The first part of the test is to look at the type of pretrial publicity. Was it inflammatory?
And what was presented, the type of pretrial publicity? So what was presented to the trial judge? He says that nothing was presented, and that the judge just said, I've read it, or I've seen it, or whatever. So what was actually presented to the trial judge about pretrial publicity?
So several affidavits were filed with a motion for change of venue from people in the community who indicated hearing extensive publicity about the case through newspapers, through the radio, various ways of the media. And
were any newspaper articles offered to the trial judge? Were there any statements about the number of news reports about the crime?
So there was no newspaper articles that were presented. However, the state did stipulate to the fact that there was extensive pretrial publicity. They agreed that under the Rawlings case, the proper procedure was to see if they could seat a jury before the judge made a ruling on that motion for change of venue. So it's the state's position that there was no deficient performance because you have not only the motion for change of venue being filed, in which it is being placed before the trial court, and additionally it should be noted that the trial court is the court that was also the post-conviction court. So Judge Geeker was able to observe the jury while it was being chosen. That he also had access to those questionnaires. But additionally,
So after, what's the second prong of the Rollins test that?
So the second prong is the actual difficulty in selecting the jury. And in this case, they did not have difficulty of the jurors that indicated that they could not put that aside. They were excused for cause. Defense used all of their peremptory challenges but did not request any additional, and there were no challenges for cause based on the pretrial publicity that were denied.
So really, the claim isn't a Caratelli claim, because they couldn't show, even on the face of this record, that there was any problem seating the jury. So it's almost as if, because they couldn't establish that, this change of venue claim on its face lacks merit.
Yes, Your Honor.
I mean, that's what so I think that you made your point.
And Judge Keeker in his motion, in his order, did state that even with the additional newspaper articles that have been provided in the post-conviction motion, it would not have changed his mind and he would not have granted a motion for change of venue.
So, I assume that the trial attorney accepted the jury after they'd gone through all the challenges for cause, peremptory challenges, and in this case, didn't the judge ask the defendant himself about the jury?
Yes, Your Honor. On page 241 of the transcript, the defendant was asked, "Do you accept this jury?" And he indicated that he did. So, and additionally, trial counsel also asked the jury specifically prior, at the end when everyone was in the room, "Can you all agree and promise me and the judge and the prosecutor, all of us, that you are not going to try this case based upon what WEAR-TV says or what Sheriff Morgan says in his next pronouncement or what the newspaper says or what, Channel 5 or Channel 10, WALA or WKRG says, and that you're only going to consider the evidence that you hear from the stand and you hear from us and that you actually see, because we don't want, I can assure you, neither side wants this case tried in the media. You see all the trappings, we have them all over the place, and what you've heard already. Can you all promise my client Patrick that you can give him his day in court, you can be fair and impartial and judge him only on what you hear in this courtroom?" The veneer responded yes. So in this case, summary denial was wholly appropriate because even if there had been an evidentiary hearing to provide all of the pretrial publicity, the motion for change of venue would never have been granted, and therefore there is no deficient performance and there was no prejudice. So an ineffective assistance of counsel claim fails. Now moving on to claim 2, Sheriff Morgan, in a letter responding to the federal district court judges, did indicate that his practice since 2007, when he was first attempting to be elected, and then following that, he made it a regular practice to greet jurors, say, "Good morning, thank you for your service. I understand that this can be imposition on your personal or business lives. You're very much needed, thank you," and gave them a business card. There are no allegations that he spoke to them about any specific case, as Chief Justice LaVarga pointed out. This jury parking lot housed both the state and the federal people arriving for jury duty, and there was no way Sheriff Morgan could possibly know who was going to be on which case, where, if they were going to be in federal court or state court. He had no idea on who the grand jury was going to be. Now, it's the state's position that Sheriff Morgan's conduct of greeting jurors and thanking them for their service is not the gross governmental misconduct that would violate the defendant's due process rights.
My only concern with it is, as he mentioned, perhaps during the course of the arrest and all those things, the publicity that goes into that kind of thing. And this was, I remember when this case happened, it was a big case in that area. If you have the sheriff giving press conference talking about how we got this bad guy, this guy's horrible, and this guy's a criminal, he's a murderer, all these things, and the sheriff is the face on TV every day, or however many days he did it, and then all of a sudden you're a juror, and you got this guy handing you a card as you walk in for jury service. There's a connection of dots there between, perhaps, that may, so I mean, I'm not saying that it is something that would require reversal or anything like that, but there's something that perhaps should not be done.
Well, the conduct that Sheriff Morgan was engaged in has since ceased, so he is no longer greeting jurors as they arrive for jury duty. However, it should be noted that Sheriff Morgan was not a witness in this case. It's likely because he was not called to testify at trial, he likely did not testify before the grand jury. While he may have been the face of the agency that conducted the investigation in the media, he was not actually a part of this specific case.
And let me see if I have this correct. He was not at the door of the grand jury room. This was all in the parking lot?
Correct.
My concern, again, having been a trial judge, because we take so much care to keep the jury out of the way of anything that may influence them. And judges really make a big effort to isolate the jurors when they come in and to keep them from hearing anything they shouldn't hear. And there's motions for mistrials based on the slightest of allegations, then they may have heard something, and that interrupts the trial for an hour, whatever, to hear that motion. We take so much care to do that, and then we have this person who obviously, for whatever reasons, is passing out his card after he was on TV saying this person is the worst thing that ever happened to this planet. It just kind of interferes with what we're trying to do in the judicial system. It just seems to me.
And I understand Your Honor's concern, but his conduct does not amount to gross governmental misconduct. He did not, there's no allegations that he said, I hope you indict Leonard Patrick Gonzalez Jr. on this case. There's no allegations that he discussed any case. He would not even be able to know which cases were going to be addressed by the grand jury when he arrived.
I guess my question, though, is both of these claims, neither claim had an evidentiary hearing, correct?
Yes, Your Honor.
And so I'm wondering, why shouldn't there have been an evidentiary hearing on this claim? I mean, you say that the sheriff just gave these out and he didn't know who was who. We say in the other issue that the jurors responded to questionnaires about the publicity, but do we have a record of really what all the publicity was? And so how do we really evaluate it since the trial judge didn't have an evidentiary hearing?
The trial judge can evaluate the record on its face and also the pleadings and what they contained, the four corners of what was alleged. And
so are you saying then that I know that our case law is you don't have to have an evidentiary hearing if the record will support the trial judge's denial of it without an evidentiary hearing. And so are you saying that this record is sufficient so that we would be comfortable saying that there was no ineffective assistance for failing to have this change of venue?
Yes, Your Honor. I think summary denial was wholly appropriate in this case. When on Claim 2, Judge Geeker in his order discussed the prejudice that had trial counsel filed a motion to challenge the indictment, it would have been unsuccessful. In this case, the evidence was overwhelming against Mr. Gonzalez and his guilt. In fact, the jury at trial found him guilty beyond a reasonable doubt, which is a much higher standard than a grand jury. In this case, Mr. Gonzalez's DNA was recovered on the AK-47, 1 in 320 trillion. His DNA was also found to be a possible contributor on one of the shotguns that was recovered. The bullet casings, the casings as well as the bullets that were recovered were from the 9mm Springfield Armory semi-automatic pistol that was recovered. According to the testimony of both co-defendants Florence and Thornton, their testimony, which was consistent with the surveillance video that was recovered from inside the home, they both testified that Mr. Gonzalez had the 9mm, and he was the one that shot Mr. Billings, and he was the one that shot Mrs. Billings. So, based on that overwhelming evidence, a grand jury would have re-indicted Mr. Gonzalez. Any challenge to the indictment would have merely served as a delay tactic. And so the trial court was correct in holding that even if you think there's deficient performance, which the trial court did not go into that first prong of Strickland and rather focused on the prejudice prong, held that there was no prejudice to the defendant because he would have been reindicted. He's not entitled to a perfect trial, but a fair trial. And in this case, Mr. Gonzalez got a fair trial. And additionally, for Claim 1, summary denial was wholly appropriate because Judge Geeker was able to observe those jurors. He was able to come up to determine that they were able to get a fair and impartial jury, and you had both defense counsel and the defendant himself agreeing to that jury that was ultimately selected.
Let me ask you a related question. How long before the arrest and the grand jury proceeding?
So Mr. Gonzalez was arrested on July 14th of 2009. He wasn't indicted until August of 2009, about a month later.
Okay.
Well, thank you. Well, unless you have something else.
No, if there are no further questions, I just ask that you affirm the lower court's order denying relief on claims 1 and 2 and send the case back down for a new penalty phase. Thank you.
Thank you. Counsel, 2 minutes. Actually, 1:55.
Okay, just briefly, counsel, I think, stated that even if you take all the allegations of our 3851 motion as true, the motion must be denied, but we allege specifically in that motion that the pretrial publicity in the case so pervaded and saturated the community as to render virtually impossible a fair trial by an impartial
Was
jury.
counsel correct when she described for us the questionnaire that was submitted to the jury?
Yeah, the questionnaire, the jurors
Did you just
responded.
forget that during your main argument, that the jurors were asked to tell what they knew, if anything, about this case?
They were just asked if they knew anything about the case, not the specifics of what they knew.
Well, so you think that it is ineffective assistance of counsel to not state in the presence of jurors, if they had not heard it at all this bad stuff that you're talking about? That's the way you say it should have been done?
That's what the Coleman case from the 11th Circuit that I've cited in my brief says is insufficient, because general questions like, would the fact that you might have read something about this case from any source influence your mind one way or another? And
Did that case ask the jurors in a questionnaire, list everything you know, such as this case did?
Well, I don't think the questionnaire gave the jurors what would elicit the kind of questions that this Kemp case requires. I don't think the questionnaire
What was
did
the
that.
question that was asked of the jury?
The jurors basically was...
No, not basically, it was in writing, so I think the question is what exactly were those questions?
On the questionnaire.
On the questionnaire.
I believe that they were asked if they knew anything about the case and if they knew anything about the Billings murders. Had they read anything or
Counsel mentioned there were 3 questions
Okay,
that dealt with the issue of the pretrial publicity
right.
in the
but-
questionnaire.
And that one of them asked them if they had heard to disclose what they had heard and gave a space for that. I thought that's what I heard. Are you saying that's not accurate?
I'm saying even if that's accurate, yeah, I think it is accurate. I'll say yes, it is accurate. But what I'm saying is you have to do more than this general type questioning. You have to get into the specifics of what they knew. And in this case, had you done that?
But there is that, if I'm understanding correctly what was on the questionnaire, that is a specific question.
Correct, but
It is not just that, did you know something? If yes, what was it? What did you know? And then you look at what they said, and then you go from there, right?
correct. But I don't think that's a substitute for individual voir dire, where you get each individual juror and you ask them what you knew, and they would all have had to have said this stuff they heard from Morgan, because it was all over Escambia County. It's inescapable. And you can't, no matter what they said, have a juror, a proper and impartial juror out of that area. Thank you.
You're out of time. Thank you both for your arguments. We're in recess for 10 minutes.
All right.